Good afternoon and welcome to our monthly BSI Built Environment webinar. Today we will be looking at the new Building Safety Act 2022 and how it will affect you. For those of us who have not met before, my name is Anne Bird and I'm Head of Built Environment at BSI, working within the National Standards part of the BSI group. And it's my privilege today to be your host for this afternoon's webinar. However, before we begin, a bit of housekeeping, if I may. Next slide, please. As you're probably all fully aware, this is a listen-only webinar that is being recorded. Okay. That said, we really do welcome your questions via the Q&A function you find on the panel before you. We've got one speaker today who I'll introduce you to shortly, but once he is complete, we will have a Q&A session. So please do take the time to feed those all important questions in. Just click on the Q&A button and post your question, and we'll try and get through as many as possible. We've already had an awful lot of questions from you, and I've already grouped quite a few of them together because a lot of you are asking very similar questions, and that's a good thing. But don't let that hold you back. Please post some as we're talking today. That'd be really helpful. If you do experience any technical difficulties, please just submit your issue via the same Q&A function on the panel before you there, and the team will help you out and get you back on. And again, a kind ask, if we may, upon completion of the feedback survey, we will send a link to the recording of this webinar to you. Thereafter, for you to go back into and look again, or share with friends, colleagues and stakeholders that perhaps you work with. It's really important when we look at the subject we're talking about today to get the message out there of the importance of this new Building Safety Act and how it will affect our industry. As is normal, this is a CPD recognised webinar, so please again request your certificate via the feedback survey following the completion of the webinar today. Next slide, please. So, as I said, we're here to consider the new Building Safety Act. I've worked within this industry for some 34 years now, much of the time working with the building regulations, both as an enforcer and as a regulator. And I can tell you that I believe this amounts to the biggest set of wholesale changes I have ever seen in terms of building and fire safety. Anyway, enough of me. I would like to welcome Dr. Hal Davies, our guest presenter today. As if you weren't aware, Hal is the Technical Director of CIBSE, the Chartered Institution of Building Services Engineers, the professional body for building engineering services, and Hal has been with CIBSE for almost 25 years now. I think I've known him most of that time. Hal leads the technical and policy development work of the institution with a particular focus on the building regulations and building safety reforms, and of course the adoption of digital information management. Hal currently chairs a number of BSI committees for digital information management and data exchange, and this is a point where I'll say thank you to Hal and CIBSE for undertaking such an important role within our professional all-important committees. BSI couldn't do what it does as the national standards body without the expertise from our sector. So on behalf of BSI, a huge thank you to Hal, but all of you, and I know many people who are committee experts are listening today. But in addition to that BSI committee work, in a personal capacity, Hal is also the chair of the Building Regulations Advisory Committee, a statutory committee which advises DLUC on the building regulations and leads the BRAC working group on the golden thread. Hal, thank you so much for taking the time to join us today. Over to you.
Thank you very much, Ant, for your introduction, and if I could also add my acknowledgement to many on the webinar today who work with many experts in BSI. It is a very significant contribution that everybody makes, and a very important one at this time. British standards are a very important part of the infrastructure in our sector. Thank you for the invitation to talk about the Building Safety Act. I agree with you, Ant, that this is the most significant piece of legislation in our sector since, I would say, since the Second World War. And I'm going to talk us through that for about 35 minutes, and then that will leave us some time to take questions. And I'm going to turn my camera off so that you can get the slides on full screen and benefit from that. So where are we now is the first question. And the simple answer is we have the Building Safety Act on the statute book, and it was passed in April, and just a quick word to the organisers. I'm struggling to get the screen to give me control. I'll give it one more go, but I am struggling to move the slides on, I'm afraid. I do apologise for that. So to give a brief summary of where we are now, this is a time of really unprecedented change in the sector. We haven't seen anything like this before, any of us. And the Building Safety Act and its supporting regulations are driving a really far-reaching review. It's probably more than half a century. And we're also seeing a significant push to greater digitalisation, modularisation, off-site fabrication and assembly. These are all government priorities, albeit to some extent being driven by a different department. The Department of Business, Energy and Industrial Strategy looks after those, and it's the Department of Levelling Up, Housing and Communities that looks after building regs. And earlier this year, we saw the latest set of changes to the building regulations come in, particularly focused on our response to net zero carbon. So changes to parts L and F for energy efficiency and ventilation, a new part on overheating, which is the culmination of many years of work to address that issue. And we also have part S on electric vehicle charging. They've all come into force, and the most recent statement from government is that we will have a future homes and a future building standard due to come in 2025. Work is underway on them. Obviously, there's been a certain amount of change going on in government recently, and we may yet see one or two more changes to the targets. But frankly, at this stage, that's all speculation. So let's go with the targets that we've got, which is those new standards in 2025. The journey really started after the Grenfell Tower tragedy, in which 72 people lost their lives. And shortly after that, Theresa May commissioned an independent review of building regulations and fire safety from Dame Judith Hackett. And Dame Judith reported in May of 2018, shortly before the first anniversary of the fire, and her report was called Building a Safer Future. And I think it's, that was a very well chosen title. That is what we have spent the last 5 years very much trying to do. And if we could have the next slide, please. Dame Judith identified 4 issues that really underpin what she described as a failure of the whole system. The first is around ignorance and misunderstanding of the regulations and the guidance. The second is around indifference. Dame Judith was quite forthright in identifying a focus on speed and cost over quality and safety. She was quite clear about a lack of clarity on roles and responsibilities, and a lack of accountability for things. And she picked up on inadequate regulatory oversight and enforcement tools, and particularly a lack of action and deterrence. I think it's fair to say that there's very little significant enforcement action because the system is so cumbersome that the costs to a local authority in taking enforcement action are probably roughly 10 times the likely penalty. And so perhaps unsurprisingly, there's little enforcement action. That's not a good position to be in, and that's one of the things that the Act seeks to address. So those were the 4 systemic failings that were identified, and Dame Judith made a number of recommendations to address them. If we could have the next slide, please. So the government has committed itself to implement all of Dame Judith's findings, and there were, I think, 53 of them. They've already passed the Fire Safety Act, which was passed last year and has been implemented through the Fire Safety England regulations for 2022. They began to take effect in May of this year, and the full requirements take effect on the 23rd of January next year. We have the Building Safety Act, and this does several things. It establishes a new building safety regulator for all buildings and not just for higher risk buildings. I don't want anybody to drop off this call at the end of today without being very, very clear that if you do building work, as Ant said in his introduction, the Building Safety Act will affect you, because the Building Safety Act is about all building work. There are people out there who think that it's all about higher risk buildings, and I guess that's understandable because it came out of the Grenfell tragedy. That was a high-rise residential building, but the Act is not about high-risk residential buildings only. It's about all buildings. There are some additional requirements for high-risk buildings, but they are additional to the requirements for everything. Anybody tells you that the Act is only about high-risk buildings, please ask them to go away and take a look at it for themselves. They're wrong. I can't put it any more kindly than that. There's a new regime for construction product safety and approvals, and we will see more on that a little later. There's going to be a new competence framework, and again, I can't stress too highly, this is for the whole industry. It's not just for higher risk buildings. And then there will be additional stringent procedures relating to HRBs, notifying work on them, and other aspects, which I'll talk about a bit later. So moving on, we now have the Act. It's available. There is a link to it at the end of the presentation, and will be available to you when you've done the feedback and got the slides. So what's in the Act? What does it actually cover? Well, the first thing is it creates this definition of a higher risk building that I just want to spend a minute on so that we're all clear. The Act defines a higher risk building. First of all, this applies to England only. There are devolved regulations in the other 3 parts of the United Kingdom. So in England, a higher risk building is one that is at least 18 metres in height or has at least 7 stories, and that's written into the Act. And then the second condition is that it's of a description that is specified in regulations. Now, you might say, well, why have they done that? Why put half of it in the Act and half of it in regulations? The reason is simple. Changing an Act of Parliament is time-consuming, it's difficult, it requires parliamentary time. It's why the 1984 Building Act got so out of date, and why there are so many amendments to that Act contained in the Building Safety Act. Putting something in regulations is a much more agile way to regulate and allows changes to be made much more readily. So the description will go in regulations, and we haven't seen the regulations yet, but consultation suggests that it will be any building that has 2 or more residential units and meets the height or story height criteria, and that will be in design, construction and operation. And any healthcare or care home that meets the height criteria in design and construction. Once it's complete, it will cease to be a higher risk building. Why is that, you ask? Because there is already a regulatory regime for the management of hospitals, healthcare buildings, care homes. We don't need a further set of regulations. there are already regulations in place. So that's what a higher risk building is, and it is there is a mechanism in the Act for extending that definition and description by adding to the regulations. Indeed, if the new building safety regulator goes to the Secretary of State with a formal proposal to extend the definition, the Secretary of State will have two options. One is to accept the recommendation, and the second will be to turn it down and provide a formal, reasoned case for turning it down. So there's a significant process there, and I imagine that over time the extent of higher risk building may well be further developed. So that's what a high risk building is, and for a residential high risk building there will be an accountable person for that building in operation, accountable for the safety of that building in law. And part 4 of the Act goes into much more detail on that. If we could go to the next slide, please. The Fire Safety Act has already come in, and some of the provisions that are there, it explicitly makes external walls and fire doors to individual flats or apartments common parts. That means that the freeholder or the person responsible for the fire risk assessment on that building has to consider the external walls, the fire doors, and indeed the structure of the building in conducting that fire risk assessment. And that is the position now. So fire risk assessments have to take account of those things, and if the fire doors are considered inadequate in that fire risk assessment, there will be a requirement to take action. There are also some more detailed provisions in the Act and the regulations around regular checking of fire safety equipment in relation to blocks over 11 metres, and also some requirements for reporting to the local fire and rescue service if certain fire safety precautions or systems are out of order for more than 24 hours. So it's a significant requirement, and people operating any building that comes in scope, you do need to be aware of that now, because some of those requirements are already in place. In relation to fire risk appraisal of external wall construction, BSI published publicly available specification 9980 on that topic earlier this year. And again, people who are involved in that, that is a document that you need to access, and it is available at no charge because the department who commissioned the PAS have arranged with BSI for that to be available to users at no charge, and that license has been covered by government. So please go and make use of it. It's there for a purpose, and people need to be aware of it. Moving on to our next slide, and I want to look a little bit more about what's in the legislation and where we're going with it now. And as an overview to the Act, it's a large piece of legislation, and just to cover some of the highlights, it runs to 171 clauses. It has 11 schedules. It's in 6 parts, and I'll talk you through the parts in a minute. It featured in 3 Queen's speeches before it was finally passed. It went through 300 amendments in the 2 houses of Parliament, and I think it occupied 297 sitting days. So a very significant piece of legislation. 298, there we are. A significant piece of legislation. But what's in it? What is the detail? And if we move on to the next slide, as I said just now, it's in 6 parts. Part 1 is very much an overview and sets out that the overall aim is to remedy the systemic issues that Dame Judith identified, to reform the regulatory system for building safety, very much about creating greater accountability and responsibility with a focus on fire and structural safety, and throughout the life cycle of buildings. Now, that's a significant change. Building regulations have historically applied up to handover. The requirements for higher risk buildings will apply throughout their life, beyond handover into operation. We have a new regulator. We have the definition of higher risk buildings that I've just discussed. And we're also going to have a new system of competence and oversight of the industry. There will be a much stronger voice for residents. The Health and Safety Executive is setting up the regulator, and within the regulator there will be a residents panel that will be, in fact, I believe the call for people to put themselves forward for the residents panel is currently open. And in addition, the Act provides additional protections for leaseholders in relation to remediation costs. It extends the scope of the Defective Premises Act to improve routes to redress. And above all, it's looking to drive a change in culture in the industry. So quite a lot in the Act. And if we move on to the next slide, we'll just have a quick summary of the Act. And also it's going to be supported by a range of secondary legislation. Now, these listed were published back in November to give us an idea of what was coming. I think you will find that they've been taken off the government website now because they have consulted and things are moving on. We're expecting that legislation to come out in the first part of next year, although clearly, given that there has been a little bit of change in government recently, I don't think we can absolutely be sure that those dates will be met. That said, this is an important piece of regulatory reform. I would be surprised if it's allowed to slip by very much, and I certainly wouldn't want to plan on it slipping. Moving on then to what's in the Act in a little more detail. And part one, as I mentioned, is introduction and scope and quite preliminary. Part two then sets out the new regulator. Part three looks at the revision and reform of the Building Act for England and Wales. And part three sets out the revision. Part four sets out high risk buildings. Part five covers construction products and architects registration. It's important to note that those provisions are UK-wide. And part six has got various technical clauses around liability and Crown application and transitional arrangements. And I'm going to move on now to look a little bit more at each of those parts in a little detail. So part one, introduction and scope. Why are we doing this? The commitment to reform, and it also explains the other things that are contained within the Act, changes to the Architects Act, to the Housing Act, and provisions for both the National Regulator for Construction Products, the Office of Product Safety and Standards, or OPSS, and a new Homes Ombudsman. In terms of the extent of the legislation, it's worth saying that much of the Act applies only to England, but parts of it apply more widely. So all of the changes in Part 3 to the Building Act 1984, the changes to the Act also apply to Wales because the Act applies to England and Wales. But building regulations in Wales are devolved to the Senedd, and it will be the Senedd and the Welsh Government who decide how they wish to apply the procedural changes in Part 3 in Wales. So the Building Safety Regulator is being set up for England. It won't apply in Wales. And then in Part 5, we have things relating to construction products and architects registration, and they will apply across the whole of the UK. I will briefly comment that that is obviously subject to the Northern Ireland Protocol, and I'm not going to mention that topic again today because I suspect that could be a whole separate webinar all of its own, and it's not one I'm offering to do for BSI. Moving on to part 2 and establishing the new regulator, we will have a new building safety regulator. It is established within the HSE and will be responsible for the building safety regime. It operates within the HSE, so that the structure and the framework for setting it up is already there, but it's answerable to the Department of Levelling Up, Housing and Communities, or whatever it might get renamed at some point, and not to the HSE's parent department, which is the Department for Work and Pensions. And it will be ministers in Duluth who will be giving policy guidance or policy instruction, I should say, to the Building Safety Regulator. Once it's up and running, it will be establishing the Buildings Advisory Committee, and there has been a call for people to put their names forward for that recently. The Residents Committee, the call is open. The Industry Competence Committee, there is already an interim Industry Competence Committee, and that will then be formalised in the next little while. And those committees will advise the Building Safety Regulator, and the current Building Regulations Advisory Committee, which is established under the Building Act, will be abolished and will be no more. So that's part 2. What's the Building Safety Regulator going to do? Well, it's given various duties. It's going to have oversight of the building control system. And that's, again, to hammer this point home, if I may, that's all building work that requires building control approval. And we'll remind ourselves what that is in a minute when we look at the slide on Regulation 3 of building regs. So building notice, deposit of plans, if it's building work, it's covered. And the Building Safety Regulator will also be setting standards and operating a statutory register for building control professionals. The approved inspectors that we're used to are going to be renamed, we think, as registered building control professionals, because anybody who provides building control services, whether in the private sector or in the public sector, will have to be registered, will have to meet the competence requirements set by the regulator, and I believe it will be an offence to operate as a building control professional if you're not on the register. And the BSR will have oversight of enforcement. Now, that doesn't mean they will do all the enforcement. Local authorities will still have a role as an enforcement body, but the Building Safety Regulator will be setting the policy, not local authorities. And it's important to note, and there's a slide on this a little later, there will be criminal sanctions. And the regulator will also be overseeing the competence requirements for work on all buildings and overseeing the duty holder and gateways for HRBs. Moving on into part 3, and I've already said this is a significant overhaul of the Building Act 1984, and so you will need a copy of the Building Safety Act and the Building Act to read side by side to understand the extent of the changes. They are very extensive, and anybody who relies on the Building Act for what they do, you do need to get hold of that and understand those changes. I think I've covered everything else on this slide already, so I'm going to move on to the next, which I think is Regulation 3 of the building regs. There we are. And this reminds us what building work is. If you're doing this, that activity is in scope of the Building Safety Act. And please don't let anybody tell you otherwise. Moving on, and I think this will take us into part 4. And part 4 defines the scope of the new regime for high risk buildings in operation. That's done by adding a new section to the Building Act, and we've covered the definition of high-risk buildings, and we've also talked about what we think the initial description is going to cover. And so all of the residential buildings that are classed as higher risk will require an accountable person in operation, and they will have statutory duties for the building safety of that building, focused predominantly on fire and structure, but they will be accountable for safety in that building. Now, I want to pick up on a term that sometimes gets used, which is the term buildings in scope. And I've got a little graphic which will help us here. Often people use the term buildings in scope as shorthand for buildings in scope of the more stringent regime set out in Part 4. And if you say the whole piece, it makes sense. Unfortunately, the abbreviation leads to a misunderstanding that it's only those buildings that are in scope of the Building Safety Act. And that is quite simply wrong. All buildings, as I've already shown, are in scope of the Building Safety Act when you carry out building work. And the regulator has oversight of the whole piece, whether it's Part 3, Part 4, it covers the whole of the operation. And I think we have a summary coming up on the next. That's it. So the regulator is applying to all buildings and building work. It's not just for HRBs. I kind of apologise for labouring the point, but I come across it so often that people think that the Building Safety Act is only for higher risk buildings, that I do think it needs nailing. And I hope that that you will be able to add to that effort in nailing it in the future. Moving on from that to look at Part 5, there are changes to the arrangements for architects registration across the UK. Architects who are the subject of disciplinary orders, that may be listed on their public entry in the Register of Architects. So those architects who transgress, it will be a matter of public record. Part 5 also makes a few changes to the fire safety order. It sets up the new homes ombudsman, and it also deals with construction products. And I think the next slide will show us that it sets up the new regulator. I'm sorry, I've skipped over the changes to charging and redress. I'm not going to dwell on them, but I'm very conscious that for people who live in buildings that have been affected by the cladding crisis, those are very important changes and necessary changes. The fact that I'm not talking about them does not diminish their importance at all. But moving on to construction products, we will have a new regulator. The Office of Product Safety and Standards is taking on that role. The Secretary of State will be regulating, and there will be a requirement, and I should have updated that line, it's the Building Safety Act, which takes powers to require construction products to be safe. There is the scope to have a list of safety critical construction products, and there will be liabilities on materials producers who provide defective products. If a defective product leads to a building being unsafe, the liabilities created by the Act are significant, and manufacturers, and dare I suggest their lawyers, need to be well aware of that. So there's a significant beefing up of the regulation of construction products, and I think we will all understand the background to that, not only in what happened at Grenfell, but some of the evidence that has subsequently emerged at the public inquiry. Moving on, so the Secretary of State will have the power to regulate construction products, and again, it's across the whole of the United Kingdom, and they have enforcement powers. So, for example, they can issue prohibition notices on products, and that has already happened in certain cases. Important to stress that the OPSS will sit within BEIS, the Department of Business, Energy and Industrial Strategy, but it is the Department of Levelling Up Housing and Communities who are responsible for construction product policy and are accountable to Parliament for that. The building liability orders I've mentioned, again, I'm not going to dwell on them, but they are really quite important. Moving on, how do building professionals need to respond? Well, I hope after all you've heard in the last 30 minutes, you will appreciate that it is quite important to respond. So we're going to have a very rigorous legal framework for design and construction of all buildings, and that's going to include the duty holder roles. Those duty holder roles are based on the CDM model, but they extend the provisions of CDM significantly. If they didn't, why would we be creating these new roles in the first place? And again, it's important to note that these apply to all building work. So any building project will need a principal designer, a principal contractor. The client will have responsibilities, although in the case of domestic work, the principal designer may act on behalf of the client. The detail is set out. And there are going to be competence requirements. And in a commercial project, clients are going to have a duty to take the original draft was all reasonable steps to satisfy themselves that the people they're appointing are competent. There are provisions in there for those in training to be working on projects, but they must be appropriately supervised. And we're also going to see the unified professional and regulatory structure for building control professionals and registration. So that's all coming, and that is going to affect all professionals working in the sector, and indeed those in the contracting side who may not identify as professionals. A lot of those working as installers at a technical level, they too are going to need to think about their competence, and employers are going to need to think about competence. Moving on, we also have beefed up enforcement provision. So the time limit for prosecutions for breach of building regulations has been removed. So that can be prosecuted for an indefinite period with unlimited fines and up to 2 years in prison. Notices for remedial action, the time limit is extended to 10 years. And there will be scope for compliance notices and for stop notices. If the regulator sees things going on a site, they will be able to intervene. And that, again, that's not just the higher risk buildings, it is anything. And failure to comply with a stop notice will be a criminal offence. So this is a more significant regime than we've been used to. For higher risk buildings, and this is specific to the higher risk buildings, there's going to be a new systems of gateways for design and for construction. Gateway 2 will be design. Construction will at the end of construction, we will have Gateway 3. And they will be hard stops. Building a building, an HRB, without getting sign-off at Gateway 2 will be an offence. Occupying an HRB after construction without appropriate sign-off will be an offence. And throughout design and construction and on into operation, there will be a requirement to record, to manage, to notify, and in some cases to get approval for changes in the design or the specification. There is the requirement for the golden thread of information to support safe operation of HRBs, and that again needs to start at the design stage. Well, it probably does need to start at the design stage. You could probably be pedantic and argue that you don't have to have the golden thread until you get to handover. But my view is that anybody who thinks that they're just going to build the thing and then sort the golden thread out later, it's not a cost-effective or an intelligent way of doing it, and it needs to be started at the beginning realistically. And if it's not there at handover, then that won't get signed off. And it will need to be maintained during operation. People sometimes ask, well, what do we have to put in the golden thread? And the working group that I chaired that came up with an initial definition, it's the information that the accountable person needs to manage their HRB safely. And if they don't know what information they need to manage that building safely, are they the right person to be the accountable person? Do they really need the government to tell them what information they need? I wonder. There will be occurrence reporting requirements if things happen in an HRB. I've mentioned there will need to be a certificate of completion. And if there are changes in client or principal designer or contractor, at any stage during the design and construction, there will be a duty to notify. And if you have regular changes in your principal designer, the building safety regulator might start to take a close interest and ask what's going on. Moving on, and I think we're into the last couple of slides now, there are implications for building owners managing HRBs. There is going to be regulation of residential buildings in operation for the first time, and accountable persons are going to have their golden thread. They're going to have to be able to demonstrate that they're managing the building safely, and that they have a system for identifying and managing risks effectively. And whilst the regulator will have certain dates at which they ask to see a safety case report on the building, and that will be revisited no less often than every 5 years, the regulator will be entitled to come in at any point and ask accountable persons to demonstrate that they are managing their building safely and effectively. That links back to occurrence reporting. If something happens in a building and something goes wrong, the regulator is likely to be in, and the first thing they're going to want is to see what's the current state of the management system. Is the golden thread up to date? Is the safety case up to date? Is there evidence that the accountable person is actively able to show that they're managing the safety of that building on a day-to-day basis? And in the worst cases, for those who can't show that, there is the potential for criminal charges. Moving on, and I think we're very near to the end now. And this, I think, is my summary slide. The changes in legislation are coming to the industry. We've got the Act. It's enabling a whole raft of further regulations to come early next year. This is not going away. The industry may have hunkered down and seen off parts of the Latham report that it didn't like 30 years ago. It ignored bits of Egan that were inconvenient. It didn't act on some of the other reports. This is not going away. The industry will not be able to ignore it. This is legislative change, and people will have to deal with it. There are going to be changes to professional accreditation. There is going to be greater regulation. We're going to have the new duty holder roles. We are going to have a new regulator overseeing building regs and building control professionals. Accountable persons are going to be responsible for their buildings. We are going to have a golden thread of information. At least it's legislated for higher risk buildings, but I wouldn't be surprised to see leading commercial property operators saying, we want that in our buildings too, please. HRBs are going to need safety cases and safety case reports, and they are going to need to be reapproved for occupation on a regular basis. And that's not just those being built now, it's the whole existing stock of some 12,500, and the regulator will be going out to those buildings once the new regime is up and running, probably at some point in 2024. They will be starting to call in those safety case reports on a risk-based system. So the HSE has already been looking, where are the biggest risks in our existing building stock? Let's start there and move on. And it's estimated that that's likely to take 5 years. That doesn't mean that people in the lower risk HRBs have got 5 years to ignore this. I suspect when the regulator asks for a safety case report, it won't be at your leisure. I suspect there will be quite a tight deadline. So people need to start thinking about this stuff now. There will be concerns about resources and timing and skills, but the message is quite clear. People need to start to prepare now. It's over 5 years since the Grenfell Tower fire. It's been clear that regulatory change has been coming for some time, and there's going to be very little sympathy for excuses later, so the time to start preparing is now. There are a couple of slides for when you download or when you're sent the pack, which gives some further reading and resources. I'm not going to dwell on them, and I will say now that those on the government website are obviously liable to change. They were up to date when I checked them at the weekend, but I can't speak beyond that. So I'm going to stop there and hand back to Ant, who I think is going to take us through some questions.
Thank you, Hal. Brilliant as always. An awful lot to cover in a very short space of time, and I thought you did it brilliantly, so thank you. Yes, you won't be surprised, there's lots of questions coming in, but there's one I just want to labour, if I may, and it'll be very quick, just because you and I have been speaking at various events and similar, and it keeps coming up. Not wanting to labour the point, but wanting to be crystal clear, Hal. These changes to which you have just taken us through will apply to more than just HRBs. Is that right, sir?
Yes, absolutely. If it is building work, it will be covered by the new regime. So even if it's your domestic extension, it's covered. Now, it's worth making one point clear. That doesn't mean you're going to have the building safety regulator round to check your extension.
No.
What it does mean is that if things go wrong on a project, then the regulator is likely to get involved. And I think it's quite likely that they are going to start asking, so who was responsible for this work where there's been a failure? Can we see the evidence of their competence, please? Client, what did you do to assure yourself that you were appointing competent people? Oh, it was somebody who'd been working for you for 20 years and you didn't do any more checks. Well, that might be an interesting conversation. Conversely, somebody's got a whole file detailing the questions that they asked of the people before they appointed and what the answers were from the people who were appointed. That will be a much more comfortable position to be in. There will be a temptation, I'm sure, to say, the building safety regulator isn't going to come and check on our job. Well, if it all goes swimmingly, no, they probably won't. But if something goes wrong, or if somebody working on that project thinks that there are problems and can't get them addressed by going through the proper internal channels, if they pick up the phone to the HSE and say, I think there's a problem on this project, well, they'll be able to turn up, and we've seen that there is an extended range of penalties available to them if they need to use them.
That's brilliant, and I'll come back to that as a question in a moment that I've had. A further follow-up, your last slide there, and there's more within your pack, and I'll take viewers today through one on mine. You've kindly provided some other links as to where people can get more information about the new Building Safety Act, the consultations that are just about to close, and where more information could be found. Is there any more advice you'd provide to our viewers today who have joined us as to where else they might go and to keep abreast of this developing situation for this legislation?
Yeah, absolutely, and a really good question. I mean, anybody who is a professional in this industry needs to be taking continuing professional development seriously. I would genuinely challenge anybody who says, I don't need to do CPD on the Building Safety Act over the next year or two. It's such an important piece, and it's such a rapidly moving piece that's needed. If you're a professional, go to your professional organisation, your professional body. They will have a journal, they will have a website. Read the journal. If I may, I write regularly in the CIBSE journal, and probably every other month at the moment, I'm talking about the Building Safety Act. And you don't have to be a CIBSE member to access that, if I may be slightly mischievous. But I'm not the only one. Use your professional bodies. They're all beginning to get stuff out on this. Some professional bodies are offering training, and just keep up to date. I didn't know about that isn't going to be a very good answer to give to the building safety regulator if they rock up on your project.
No, I think so. Well, through our discussions that we have through BRAC and similar, I think that's very much going to be the case, and that it will not be well received. Okay, thank you for that. Moving into a bit more technical depth about what you've covered today, Hal. I want to move into the realm of competency, and we've had a lot of questions come in terms of broad competency. We've had a question come in from David. Who under this new legislation is deemed a designer? And could a specifier who selects a construction product for incorporation into a building in the future be classified as offering design advice. What's your thoughts on that, please, Hal?
Well, the very simple answer is yes, but I think David and others might want me to go into a bit more detail. I half expected this to come up. So if I can, I'm going to read to you the latest thinking on this from the department, which was in the consultation document issued in July. A designer, they say, any person who, in the course or furtherance of a business, carries out any design work or arranges for or instructs someone under their control to carry out design work will be a designer. So if an electrical contractor, and this happens quite often, an electrical contractor is brought in by a client to replace the lighting on one floor of a building, and the client says, I want you to redo the lighting. If the contractor then decides, well, I've done a few of these, I'll use these products and I'll do it this way, that contractor, to me, is clearly a designer.
Yeah.
If the contractor goes to a manufacturer or possibly to a distributor and says, I've got this job, what have you got that I could use? I think at that point, manufacturer or distributor needs to take a very deep breath and ask itself, am I competent? And dare I say, am I insured to act as a designer? Because I need to think very carefully about how I answer that question. Because I think if the distributor says, oh, I'd whack a load of these in, I think they've just become a designer under this.
Yeah, I mean, that's a really important point for people to be aware of. And again, part of the need to understand how this will affect you. As somebody who's ex-building control, you know, I was always guided that building control don't give advice on how to show compliance. In fact, taking this forward, that would be perhaps even made more clear to the building control fraternity that they will be determining whether compliance has been achieved or not, but they can definitively not give such guidance. Otherwise, they could be implicated too, potentially.
Oh, absolutely. I mean, I think we've got to get ready for a very significant shift in the way that building control professionals work. They will be there to assess whether the principal designer and the principal contractor have convinced them as building control professionals that the designer and contractor can demonstrate that they've complied and know what compliance is. It's the designer and contractor who have to comply. Building control are there to assess whether they're convinced. And in one sense, building control will come in and either give it the thumbs up or the thumbs down. Now, I think they will have to explain why they have given the thumbs down and what they are not happy with. But if they're then asked, well, what do we have to do to comply? The answer will be, you're a competent contractor or you're a competent designer. You should know it is not my job and I can't tell you.
Yeah, absolutely. That's a really powerful point, Hal. Thank you. Staying with competency, and I'm mindful of the time, but we've had a lot of questions. We've had a question from Adam. And it's good to receive these because quite often we don't get too many questions from contractors. And the question is, what assessments for competency do the actual main contractors need to carry out? Plenty of emphasis on the designers and approvers, but I see no formal competency regime for the contractors. How?
Really good question, really fair question. And I think, you know, there's a tension here. The regulator has made it clear that they're not going to provide us with a checklist that in order to do this job, you need to have this card or this certificate or this diploma. And it will, to some extent, be for the main contractors to decide, what do we think a competent person to undertake this task should have? And main contractors may say, well, for this sort of job, we want this sort of person. So there's going to be a degree of responsibility on contractors to decide for themselves what what they think competent looks like. I hope that there will be some discussion across the wider industry. The Competence Steering Group has done a lot of work on this. Working Group 2 on installers, for example, has given some guidance on what competence looks like. The relevant trade bodies need to be having this conversation across businesses. But the other end of the tension is that if the building safety regulator is going to prosecute somebody for not appointing a competent person, there's going to have to be some sort of benchmark against which they can say, this is what we believe competent looks like, this is what you did, and we believe we can show to a court beyond reasonable doubt that what you did does not meet the benchmark. And it's really important that the regulator gives us those benchmarks, because the criminal test is beyond reasonable doubt. And if people can go into court and say, this trade body says this will do, that trade body says that will do, I don't know what I meant to do. I think it would be much more difficult to demonstrate that somebody has acted criminally beyond reasonable doubt. And there is a lot still to come out on this, I think.
There is. Thank you for that. And just to say, I'll provide a link at the end, because working with DLUC, the department, BSI, with stakeholders and expert committee members, have developed a suite of guidance on a competency-based framework with some vertical passes beneath for principal designers, for principal contractors, and for building managers. But actually the interface between how the regulator ultimately decides whether they convey status on that approach, or what other conditions they set, we'll be seeing that forthcoming in the new secondary legislation. How? I'm afraid we've run out of time. We should have extended this for a far longer period. We've got a number of questions coming forward. All I'd say to the people that have joined us today is that we will have a few more events coming up as we step towards the end of the year, where we will pick up and actually cover this very important issue again. And actually there's one coming up towards the start of December, which will actually have the HSC there as well. So let's stop there, and let me draw this to a close. But Hal, as always, thank you to you, thank you to Sibsi for allowing you the time to come and do what you do for us, both at BSI and for DLUC and similar. As I say, we'll have you back again many times, so we'll be in touch. If you could come and join us, that would be wonderful, Hal. Okay, let's draw this to a close. If we can kindly move to the next slide, please. This could be difficult. Thank you. As I say, huge thanks to our speaker today. I'm sure you found him hugely insightful, and as I say, we'll get him back again, no doubt. From my perspective, just a couple of things before I go. If you found today very useful, all of our events can be found on the link that you have before you there. A couple of points to shout out. There is another webinar, it's not actually on here, but there's another webinar this afternoon looking at the Fire Safety Act 2022 that was touched upon by Howell earlier. So that starts at 2:30 today, so it's not too late if you want to join us for that. We'll be having Nick Coombs from the National Fire Chiefs come and join us to take us through that. But also some other things that you might find useful. On the 29th of November, we have another webinar in the series looking at Approved Document B, Fire Safety, a latest update there, which you actually might find very useful when I look at some of the deep technical questions about the applicability of 9999 and 9991, where we can cover those off in a bit more detail with you. We then have, over the course of 2 days, but we'll do it slightly different going forward, we've got our Built Environment Summit for 2022. 4 component parts: health and safety wellbeing in the morning, which I'll host, and we'll be having Peter Capelhorn, Senior Committee member there and CEO of the Construction Products Association, giving a bit of a state of the nation, covering a multitude of areas, including construction products. We'll then be joined by the HSC, who will take us through their role as the new building safety regulator, as Hal set out today. We'll then have a further discussion around construction products and safety critical products, and then we'll finish. We'll have a presentation on a new PAS looking at neurodiversity and the ability to design the built environment in a far more acceptable way for the needs of everybody, including our neurodiverse society. But that then is just the first component part. We'll move on to cyber and physical infrastructure, the digital piece. We'll be looking at quality in the built environment, and then we'll be looking at off-site construction and modular construction too. As promised, there is also the link to the competency programme of work that BSI have undertaken, working with the department and the sector, where you can download all the free content that you need, which touches upon the competency piece that we've covered today. Other than that, it's just a big thank you from me. Thank you to you for making the time to come and join us today. I think we've had some 420, 430 people join us today. So thank you. Huge thank you again to Hal for taking time out of his very busy diary to come and present to us all. And a huge thank you from me to the BSI team that make these events happen. Have a good rest of the day. It'd be great to see you just after lunch for the fire safety webinar too, if you're free. Bye for now.